Viagra. I don't know how many of you have actually used this, but if you have, there's nothing to hide. This is a safe, certified medicine being produced and sold by a very large and old established brand called Pfizer Products Inc. So, ladies and gentlemen, welcome to the all new episode of the Utsav Mukherjee IP and Tech Law Show. Today's episode will be called The Viagra Story. It's been quite a while since we last met. Yes, I was just so caught up with so many things in between, branching out from the law firm that I was working with and kickstarting my own boutique setup, working on new cases before courts and new trademarks registry related cases as well. But that's enough about me. Today's episode is about the Viagra story, and it's about the trademark of the brand Viagra and a recent case before the Delhi High Court, or should I rather say a heated battle before the Delhi High Court, in which one brand sued another entity using a similar name, right? And the similar name to Viagra that was being used by the other entity was called VIGOURA. So today's episode is of particular interest to me as it involves elements of IP law pertaining to the pharmaceutical industry, a sector which I've personally serviced quite a lot as an IP attorney, both in court matters on the litigation side as well as before the trademarks registry on the what we call the prosecution side in IP. So today's episode is a bit longer than a lot of my episodes, not too long, though you won't get too bored. And this is because the case is so interesting that I wanted to cover some of the essential aspects for, those people who want to know more about how IP cases work, in-house IP attorneys who, or would find this kind of a show interesting anyways, or say IP litigation attorneys who would find this kind of a show interesting. Anybody who's associated with IP and registry work, also prosecution work, or generally law students or founders, entrepreneurs, people from the pharma industry. So for all of you, this would be an interesting episode. So Pfizer sells Viagra, which is a well-known allopathic drug, right, for curing erectile dysfunction. Now Pfizer sued another company called Renovision for selling a certain homeopathic medicine called VIGOURA, right, which allegedly also cures sexual disorders. And Pfizer claimed that this name VIGOURA, being used by the defendants, was deceptively similar to Pfizer's own medicine called Viagra. So interestingly, when the suit was first filed by Pfizer, it was only for passing off, right? And which is a common law remedy, and it was not for trademark infringement at that point of time. However, later on, it involved many more elements than just passing off. So it involved the element of IP infringement, also some other elements of IP law, right? Now, let me tell you a bit about the case set up by both the parties, that is the plaintiff, that is Pfizer, and the defendants. So the plaintiff Pfizer pleaded that it was a large global pharmaceuticals company, and it said that it had a vast presence internationally in about 150 countries, and that they had even been acknowledged as the number one company in the year 1998. They said that the trademark Viagra was first adopted by them in the year 1995 for a drug that they had made to treat erectile dysfunction. They also discussed the extensive publicity and media attention that was generated for Viagra. For those listening who aren't familiar with trademark law, parties that sue for trademark infringement have to show figures of expenditures made on the promotion of their trademarks, which is why the plaintiff in this case also discussed how it generated publicity for its trademarks and its vast presence across the globe. Now, basically, what you have to show the court is how your trademark is worth a lot and that the market identifies you from that mark whenever they see or hear the name of your trademark. So the plaintiff discussed how its trademarks were renowned both in India and worldwide, and they relied on a case called Pfizer Inc versus BL Company and others, in which the court had even acknowledged Viagra as a world-renowned trademark, despite the fact that Pfizer was not even making direct sales of Viagra products in India back then. Now, let me tell you about the claims made by the defendants. The defendants claimed that its drug, Viagra, was not Viagra, it was Vigura. See, it's so confusing that even while speaking, one could say Vigura, Viagra, because the names are so similar. But that its drug, Vigura, the one of the defendants, was of a completely different kind from the plaintiff. And it said that its drug was for vitality and for regulating menstruation, unlike the plaintiff's Viagra drug, right? And they said that their drug was a homeopathic medicine. It was not allopathic like the plaintiff's drugs. So they were differentiating the categories of the drugs, right? They're saying how their mark, even if it is somehow similar to the plaintiff's mark, It's for a completely different kind of product, you know. Now let me get to the court's analysis, right? So the court, after hearing both sides, gave its decision. And in its judgment, the court analyzed each of the issues that had been framed by the parties, right? First of all, they analyzed whether the plaintiff was even the proprietor of the mark Viagra. The court noted that the mark Viagra was distinctive and arbitrary, which means that it was not descriptive in nature or common to the trade, which are some of the key features of any legally valid trademark. So any trademark that you apply for those who want to apply for the trademarks who are listening, your mark has to be distinctive. It cannot be something which is common, like say pizza, or which is common to a particular trade, right? It has to be something which is unique, distinctive, arbitrary, right? So the court found the fact that the plaintiff had applied for and had even been granted registration of the mark Viagra by the Trademarks Registry of India, had also obtained registration of the Viagra mark in hundreds of other countries and had established their vast presence and use in the market, both online and offline. And they said that this proved the fact that, the plaintiff had proprietary rights in the mark Viagra. Next, the court analyzed whether the defendants were guilty of committing infringement of the plaintiff's trademarks, right? And this is the interesting part. Because most people think that in a trademark dispute, what matters is which party has an earlier date of registration. Now, this is the law in China, but in India, this is not the case. In India, what matters is which party is the earlier user of the mark, which has the earlier date of proven usage or adoption of the mark. So if my mark has been adopted prior to yours and has been in use before your trademark, even though you have a registration which is before mine, my trademark would be upheld over yours in a dispute where they're both similar, right? Now, in the present case, the plaintiff first introduced the name Viagra to the market for its products in the year 1995. And in India, it filed its trademark application in the year 1996. So take note that they only filed their application in 1996 and it wasn't yet registered. They first commercially used the mark Viagra in India only in the year 2005. In contrast, the defendant first used the mark VIGOURA in 1999. So this means that the defendant first commercially used the mark VIGOURA 3 years after the plaintiff filed their trademark application, right, for the mark Viagra. And the court explained that in cases where one party has already had a registration for a mark and another party has shown usage prior to that registration, they would only be considered a prior user if they have used the mark prior to the other party's application for trademark registration. So you see, this is another catch with that whole prior usage and prior registration issue. So the court also found that the marks Viagra and Vigura were phonetically similar, right? Which means that they sounded the same. It explained that such similar sounding names of the same class of products could easily mislead and confuse customers. The court explained that when deciding whether a mark is infringing and passing off another, what is seen is overall similarity in the two marks, right? And how likely they are to confuse customers. In this case, both the marks were visually and phonetically similar. Further, the court found that in cases of pharmaceutical products, an even more precautious approach has to be taken, as the consequences of confusion being caused to customers due to similarity of names or labels could be very serious. It could even be life threatening. Then the court also considered the transborder reputation of the trademark Viagra. It considered the fact that even though the product Viagra was introduced in the Indian market in 2005 only, the Indian public was very well informed about this brand from news available in print and online media, and from the website of the product, which was accessible globally even as far back as 1990s when the product was launched globally. So you see, they're looking at the global presence of the mark even more than the Indian presence to see its value as a trademark and how well recognized it was. Because in IP cases, what matters a lot is how much the public actually identifies with your mark. If your mark is something which reminds the public of your product, right? Or you have a good presence in the market domestically and internationally. These are factors that are seen. Now, regarding the argument of the defendants that even there were other trademarks similar to Viagra in the market, and some of them were even registered, why did the plaintiff never take action against them? The court said that this is not a case for justification for the defendant's acts of infringements, and it is the plaintiff's choice, right, to see who they want to file a case against and who they don't want to file a case against. And lastly, the court awarded nominal damages of 3 lakh rupees, 3 lakh Indian rupees. And this small figure may sound disappointing to a lot of you, I know. Indian courts aren't, as big as the American courts when it comes to damages and compensation. But that is just a difference in the legal systems. maybe they don't want to promote people to sue over here. Right? And this is all about today's exciting episode in the Viagra trademark battle. And I want you to stay tuned for more exciting episodes on developments in the world of IP and exciting court cases. So see you soon. Cheers.